kepada teman-teman sekalian yang sudah tergabung sebagai attendees. Kita masih menunggu peserta-peserta lain dan sesuai schedule kita akan memulai pukul 12.46. Jadi silakan ditunggu dan terima kasih.
Selamat siang Mbak Isna.
Terima kasih. Selamat siang Mas Iga, Mbak Isna.
Selamat siang Mas Daudi.
Maaf, aku baru tadi habis away sebentar, baru kembali lagi ke depan laptop.
Oke.
Teman-teman ALSA juga.
Sehat Mbak?
Alhamdulillah.
Yeah.
Gimana di Jogja? Di Jogja?
Jogja.
Oh iya. Masih kampus tapi?
Kadang-kadang aja sih.
Oh iya.
Ngajar dari rumah sih sementara.
Ngajar dari rumah, ya.
Oke. Dari Walhi jadinya siapa, Mas?
Mas Yuyun, Mas.
Mas Yuyun. Oke.
Oh iya.
Good afternoon, everyone. We'll start the show in 5 minutes while waiting for one more speaker to enter this webinar. Thank you for your patience. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya. Greetings to all of us. Before I proceed, I would like to introduce myself. My name is Zuhdi Aryawan, and I will be your MC for today's legal English discussion. First and foremost, good afternoon to our honorable speaker for ALSA Law Unplugged Vol.2 legal English discussion, Mas I Gusti Agung Madewardana, SH LLM PhD, Mas Yunarmono, and Baisna Fatima, SH LLM. Our moderator for today's discussion, Kak Audrey Kurnianti. the Board of Directors and staffs of ALSA UGM, and all of our honorable participants of the legal English discussion of ALSA Law Unplugged Vol.2. Let us praise our thanks to God Almighty, for it is because of His grace that we are able to gather around today to discuss the debate on the abolishment of AMDAL, or environmental impact analysis in Environmental Law of Indonesia. Our series of today's event include the opening, which is currently ongoing, opening remarks by the project officer, opening remarks by the director of ALSA UGM, discussion that will be led by three of our most outstanding speakers, and followed by Q&A session. It should be noted that participants who have joined via Zoom may ask questions through the Q&A feature, and participants who have joined via YouTube may ask questions through the comment box. Next, the giving of placards to speakers and moderator, and finally, jamming session by ALSA Singer and awarding session, which will be hosted by my colleague, Fian. And for the next session, we will be having the opening remarks by our Law Unplugged Vol.2 project officer, Tuhramat Akbar Berliano Ulurura. Welcome, the time is yours.
Hello Arya, am I audible?
Yes, Rabel, you are audible.
Okay, bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya. Greetings to all of us. First and foremost, good afternoon to our honorable speaker for ALSA Law Unplugged Vol.2 Legal English Discussions, Mas Igusti Agung Madewardana, SH LLM PhD, Mas Yuyun Harmono, and Mbak Isna, SH LLM. To our moderator for today's discussions, Kak Audrey Kurniati, to all of the board of directors, local board and staffs of ALSA UGM, and all of our honorable participants of legal English discussions. Ladies and gentlemen, a very good afternoon to you all, and once again, welcome to ALSA Law Unplugged Vol.2 2020. Law Unplugged is an event organized by English Development Divisions, which is a forum for legal educations to the society in a more flexible, fun, and innovative way, which is with a platform of art. And hopefully, it will bring up fresh ideas for educating, raising awareness, aspiration forum, and to develop the art skill of the society. The theme raised in the Law Unplugged Vol.2 this year is Environmental Heroes, where the substance event will be more on environmental issue and environmental law, especially in Indonesia. There are 4 agendas for this event, which are art competitions, art exhibitions, legal English discussions, and movie sessions. And now, currently, we are on legal English discussions agenda. As we know that the government plans to abolish AMDAL, but this raised the debate between the two opposing parties. One who supports the abolishment of AMDAL in interest of economic growth and investment, and the one who disagrees with the abolishment of AMDAL considering the environmental sustainability. Thus, what if AMDAL is really enough? It comes to big questions. Does it have a big impact on the environment? Legal English discussions will provide you great speakers to discuss more about it. Mas Igam, Mas Igusti Agung Madewardana, Mas Yuyun, and Mbak Isna. And these discussions also will be led by Audrey Kurniati, and she is one of the awesome students that we have in Faculty of Law, of course. We really hope that this event can bring a lot of insight and knowledge and resources for us to do much better in the future. Maybe that's all I can say. Sorry if I made a mistakes, and I hope all of you can enjoy this agenda and take a good point of it. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Om, Santi, Om. Namo Buddhaya. Thank you, Arya.
Okay, you're welcome. Thank you, Rahmat Akbar Berliano Ulurura, for the remarks. Next is the opening remarks by the director of ALSA UGM, Tuga Gaudi Demisha Verdi. Welcome. The time is yours.
Okay, thank you for the opportunity. Am I audible?
Yes, you're audible, Kak.
Okay, bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya. To our distinguished and honorable speakers, Mas Igusti Agung Madewardana, SH LLM PhD, or in the Faculty of Law, we would like to call him Mas Igam. Thank you for coming, Mas. Mbak Isna Fatima, SH LLM. Thank you for coming, Mbak. Mas Yuyun Harmono. Thank you for coming, Mas. Mbak Audrey Kurnianti as our moderator today. Mas Rahmat Ulurura as the Project Officer of Law Unplugged Vol.2, the Committee of Law Unplugged, the local boards of English Development, and fellow participants. Firstly, I would like to express my gratitude to God for the grace and mercy that has been given to us, which led us being where we are at the moment. And I would also like to give my gratitude to the Committee of Law Unplugged Vol.2 for their dedication and commitment in organizing this event as a manifestation of their passion. So as Rabel said before, Law Unplugged is an event which serves as a media in giving legal education to the society by using art. And one of the events within Law Unplugged is Legal English discussion, which we are currently having right now. So yesterday we were able to discuss with Mbak Tiza Mafira regarding the disruptive existence of plastic in our world and what can we do as a human being to save our own world through one of our events in Law Unplugged, which is movie session. And today we dig deeper into another aspect in the environmental field of study, which is the debate on the abolishment of AMDAL in Environmental Law of Indonesia. So this topic is chosen by us because we feel the importance of understanding AMDAL as one of the business licenses in Indonesia, and it's key for us to learn the impact of the abolishment of AMDAL. And as Rabo said before, we are blessed today with honorable speakers that will lead us to various perspectives and knowledges regarding this specific topic, which revolves around AMDAL, RDTR, and other environmental licensing instruments. I hope that with all the limitations and adjustments we have been facing for the last couple of months due to the pandemic, we can still gain various knowledges and experiences through events like this. And to conclude, thank you for your attention and participation. I hope that all of you will enjoy our event today. Stay safe and stay healthy. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Om Santi, Santi, Santi Om. Namo Buddhaya. Line for excellence, ALSA, always be one.
Okay, thank you, Kagodi, for the opening remarks. We'll now commence to the core of today's event. Before we begin, I will now introduce our moderator for today, Audrey Kurnianti. Audrey is a student at the Faculty of Law in Universitas Gadjah Mada. She's also the president of Community of International Moot Court Universitas Gadjah Mada. She participated in numerous competitions such as 2019 Direct Investments Arbitration Moot Court in Miami, United States, and 2018 International Humanitarian Law Moot Court Competition. During her studies, she has also received many accolades. She was a top advocate where she was in the 24th position out of 155 advocates in the Foreign Direct Investments Moot Court Competition, top 5th ranked team in the preliminary round, and top 114 ranked team overall score in Foreign Direct Investments Arbitration Moot Court Competitions, 4th best oralist in International Humanitarian Law Moot Court Competition, most outstanding delegate, and best position paper in VJ Model United Nations, and many more. In addition, she has also participated in several committees that are no less prestigious, such as being the treasurer in the 6th Asian Law Students Association International Legal Training and Workshop in 2019, and one of the substance team in Jogja International Model United Nations in 2019. Therefore, without further ado, let us begin. Welcome, Audrey. The time is yours.
Thank you so much, Mas Zudi Aryawan, for introducing me. So, hello everyone. Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, Namo Buddhaya. Welcome everyone. Firstly, I would like to thank everyone who is already willing to participate in today's event. This include our amazing speakers, Mas Igusti Made Iga Mardana, Mas Yuyun, and Mbak Isna Fatima. Thank you so much for attending to this event today. And I would like to also extend my deepest gratitude to all of the committee and also Mas Gaudi Averdi. Thank you so much for having me in this event today. So without further ado, I think you guys are already, wanting to learn more about today's event. So we will have our discussion in regards to the possibility of the abolishment of AMDAL due to the RDTR, which are going to be discussed later on. What is actually the difference between two of these environmental documents or environmental licenses? And we will begin by firstly going to our first speaker, Mas Igusti Made Igam Wardana. Hello, Mas Igam. I think you are still muted, Mas.
Thank you, Audrey. Good afternoon, everyone. Thank you for ALSA for having me in this discussion. I'll be the first speaker in this discussion. And before I start, I suppose that there would be no debate in this event because all speakers seems to be in similar positions on the matter of environmental impact assessment in Indonesia, especially with regard to the most recent omnibus bills of job creation, which proposes to weaken the EIA system in order to boost investment. And the title of my talk, could you, the host, share my PowerPoint or my slide, please? Yeah, the title of my talk today is Debating Environmental Impact Assessment in Indonesia. Yeah, okay. Can you see the Yep, can you see it?
Yes,
all right.
Yes, we can.
Okay. Yeah, again, the title of my talk today is Debating Environmental Impact Assessment in Indonesia. In this regard, before going into the debates on, especially on the reason why the environmental impact assessment or the EIA system in Omnibus Law proposed to be weakened, I will first start by giving you the context and the conceptual understanding on what environmental impact assessment is really about. And so we are aware that it is an important instrument for us to protect the environment, despite the fact that in reality, we know that it is very often overlooked or underestimated. The next slide, please. Yeah. Environmental impact assessment, or EIA, was first introduced in the US around late 1960s, following the advancements of the industrial technologies leading to rapid environmental destruction and pollution. It then has been duplicated in many countries, including Indonesia. Right now, it is hard to find a country that doesn't have an EIA system. This means that the system is universally accepted as an instrument to implement the principle of preventive action, incorporating three different decision tools. The first one is the management tools related to the institutional management of the environment. Second, process-based tool with regard to ensure the production process comply with environmental standards. And thirdly, the product-based tools. This is related to the product that is proven to be environmentally friendly. In the development of EIA, it is now widely agreed by the scholars that the EIA is both science and art. It is a scientific exercise, especially with regard to the technical aspects. It assesses environmental indicators to identify the future consequences of a current or a proposed activity of a project. Environmental indicators here are two, which are environmental performance indicator consisting of two aspects. The first one, operational performance indicators and management performance indicator. And the second one, of course, environmental condition indicators, which is the conditions of the environment where the project is proposed. This is because the impacts of a project would be site-specific. That is why environmental condition needs to be assessed specifically as the baseline on seeing what would be the impact of this activity when taking place in particular area. The next one, please. However, beside the scientific exercise explained just now, environmental impact assessment is also a state of art. It is also an art. It is related to the purpose of the EIA. There are three purposes of EIA, which are the first one, EIA is an aid to decision making. This is because at the end of the scientific exercise, the findings of the study should be used for making a decision for the future of the project. And the second one is an aid to the formulation of the development action. Here, environmental impact assessment, or EIA, is used to determine whether or not a particular development project is allowed to take place in a given area. And the last one is EIA is also an instrument for sustainable development. We know that we learn about this. Definition of sustainable development is very often referring to Brundtland report, in which it defines sustainable development as development which meets the need of present generation without compromising the ability of future generation to meet their own needs. Here, sustainable development has three dimensions, which are economic, social, and ecology, or the environment, as we know this already. The question would be, what is the connection between the EIA system and sustainable development? The EIA system is designed to pursue sustainable development by determining whether or not a proposed activity or a project is economically, socially, as well as environmentally feasible to proceed. Indeed, environmental impact assessment is an art is closely related to decision-making process. In this regard, the EIA is a public policy that is never neutral, but it is politically laden, in which many interests are competing against another, the interest of the project proponent, for instance, the interest of the local communities, the interest of the government, as well as the interest of the environmental NGOs. Hence, policymakers should consider all interests in the process seriously. From this understanding, this is why the EIA process should both involve a scientific procedure and public participation at the same time during the process. Next one, please. Yeah. In conducting EIA, there are 8 guiding principles, which are participation, transparency, certainty. This certainty is with regard to whether or not to undertake EIA is mandated by a law in a given country, for instance. Then accountability, credibility related to the issue of scientific methodology and assessment, cost-effective, flexibility, and practicality. Besides those principles, an EIA system is evaluated based on 3 criteria. The first one, effectiveness. The question would be whether or not the system delivers its purpose, or especially to prevent the pollution or the environmental destruction to occur. And the second one is efficiency, whether the system is cost-effective and timely. And the third one is about fairness. The question here is whether all interests are taken into account and whether there is a mechanism provided to challenge the decision that has been made, or we usually refer this as the access to justice. This access to justice is also part of the criteria in order to evaluate whether we have a good EIA system or not in one country. And the next slide, please. Now, let's move to the EIA system in Indonesia, what we call as AMDAL. Yeah? AMDAL was introduced in 1986 under the environmental law regimes of 1982. Then it was simplified in 1993 due to dominant neoliberal paradigm in the development policies. In 1990, it was refined, then it was improved by the 2012 regime, the current AMDAL regime we have in Indonesia. When we try to compare all the regime we have regarding AMDAL, there are several important changes from time to time. I'm not going to explain all of them. I will try to focus our attention at least on 3 aspects of this comparison, which are the public participation, point number 3, the review mechanism, point number 4, the next slide, and access to justice, the point number 6. When we look at the public participation, we know that there has been an improvement in opening up space for public participation, yeah? Where in the regime 1986 regime, there was no public participation. We know we were under authoritarian regime at the time, so public participation would not allowed by the government. And we moved to 1993 regimes. Also, similar things also was happening. There was no public participation, although the limited public participation was stated in the regulation, but basically in practical, there was no participation whatsoever. And in 1999, because we know that at the time we were under dramatic change in terms of state structure from centralism to decentralism, then we try to accommodate the possibilities for public participation in the regulation, although it's really limited. But the current regime, 2012 regimes, it opens even widely the possibility to participate in the AMDAL process. From this, we know that there has been an improvement in public participation in AMDAL process from the 1986 regime to 2012 regime. And the next slide, please. Yeah, with regard to the review process, there are also an improvement, from the 1986 regime to 2012 regime, from review conducted by the government, associated with government, into review conducted by scientists under the EIA review commission, or we call it team AMDAL, Tim Penilai AMDAL. It also shows us the improvement of how the AMDAL document has been reviewed from time to time. Nowadays, it has been a very ideal one where the scientific document, AMDAL as a scientific document, is reviewed by scientific committee. That's a good one. And then the last one, with regard to the access to justice, from time to time, we also see an improvement in how to treat the document, the AMDAL document, the outcomes of AMDAL documents. Yeah, for instance, before 2012 regime, AMDAL document was only considered as a formalistic requirement for granting a license. But nowadays, it's a compulsory requirement for getting an environmental permit. An environmental permit is treated as a decision from the government and then can be challenged and subject of administrative court. So we can nowadays challenge the AMDAL process in order to check the validity of the AMDAL process and to check the formality and even the merits of the AMDAL through the environmental permit at the administrative court. So it also shows an improvement. Time by time, we try to improve the AMDAL system in Indonesia. And next slide, please. We understand that the AMDAL regime we have is not perfect. We know that. In reality, in the implementation, we can see so many loopholes, so many problems as well. And we know that's not perfect. But at least for me, it is better to have something in place rather than nothing. Yeah, at least we have the system in order to prevent. What if we don't have it? Yeah, that will be the problem, the biggest problem we face with regard to the environment. And considering the existing regime, the imperfect regime of AMDAL, many people have criticized the AMDAL regime, the current AMDAL regime. I observed that there are at least 5 main issues criticized by scholars, activists, and even business sector, which are the first one, the AMDAL regime has a little effect upon decision-making process. It's argued by activists and scholars, and I agree with that. Although we have AMDAL, it's not necessarily we can prevent environmental destruction or pollution, but also it's still happening. And that's why we move to the second point, in which few tangible environmental benefits. We can see that. We can see clearly that although we have AMDAL in place, environmental degradation and pollution continues, even exponentially. It's argued by activists and scholars. And also, activists argue that inadequate opportunities for public involvement. We know that already. Sometimes in the AMDAL process, the space for participation has been closed by a particular government entity in order to reduce noise, or we call it the politics of noise reduction, to reduce the noise in the AMDAL process. But in the norm, we still have that the possibility to get involved in the participation in the decision-making process. And the next problem, the next point criticized by business sector is being costly. Of course, we know that in making AMDAL document is very costly, and also from business point of view, AMDAL is seen as a source of delay, or if also as a source of rejection of the AMDAL, of the project, and then that's argued by business sector. Hence, from those critics, we can put them into two categories. The first one, the skeptics, who seek to weaken or even to get rid or abolish the AMDAL completely as a compulsory development requirement. Here, the business sector is clearly part of this category. The business sector is part of the skeptic group, with seek to weaken or even get rid of the AMDAL altogether. And the next the next category is, I call it as the revisionists, who demand improvement, persistent improvement of the existing EIA regime to widen public involvement, public participation, and to ensure that standards follows its implementation and so forth. Here, the scholars and activists fall into this category. We know that the system we have right now is not perfect, but we need to continuously improve that. And the next slide, please. And then we try to relate these critics into the omnibus bill. The next slide, please. If we relate this to the omnibus bill concerning job creation that has been approved by the legislative body to put forward into the next plenary session, we understand that the skeptics overrides the public policy and discourse on AMDAL in this country. This is exactly because the skeptics, especially business sectors, have been given more space by the state to express their dissatisfaction toward existing environmental regime, including to formulate their own interests on how to change the regime based on their business interests through the omnibus bill. There are several changes proposed in the bill, which are: first, taking over the assessment and monitor by the national government. This would overwhelm the national government due to limited resources to conduct monitoring to all EIA documents that have been approved across the country. Lawmakers are very aware of this limitation. The question is, why then they seem to ignore it? For me, this is not a sign of ignorance. This is something to do with the politics of the impossibility to monitor, because it is by design that the EIA document is impossible to monitor, so that project proponents basically should not bother themselves to comply with the recommendation of monitoring or managing its operation based on the environmental standard or environmental safeguard. And the second one is deleting the existence or abolishing the existence of the EIA review team of the AMDAL team, AMDAL review team. Consequently, the AMDAL document will not go through a scientific review, but rather it goes to a bureaucratic review. The nature of this review, the nature of these two are very different. The scientific review is based on scientific objectivity, in which scientists in the review team will conduct the review seriously based on their competency in order to maintain their credibility. If they conduct the review not in serious manner, then they might jeopardize their credibility. However, in the bureaucratic review, it is conducted by the government officials or other certified parties, namely private entities, based on the assumption that the project should go forward so that the government might pursue economic development. If we relate this to the mining law number 3, 2020, that just enacted by the government last July, or if not mistaken, July or August, this tendency is clearly stated in the law. The mining law provides a guarantee from the government to issue related permit for undertaking activities, including in this regard is environmental permit. When you have such guarantee, when you have the guarantee from the government that you will have the environmental permit, there is no point anymore to undertake AMDAL study seriously, because in the end of the day, whatever the result of the study cannot be used for overrule the guarantee, because the guarantee already there. Whatever the finding will be, then you will have the environmental permit. And finally, the Omnibus Bill reduces parties who can get involved in the EIA process. Currently, there are 3 parties to get involved. They are direct affected communities, indirect affected communities, environmental organizations. The Omnibus Bills only give the direct affected communities to participate in the process, while indirect affected communities and environmental organizations are deleted from the picture of participation. Although, especially in the case of environmental organization, the requirement of involving them to participate because the recognition of the value of the environment, which is the organization represent. Once they are not allowed to participate, that the interests of the environment would not be not be taken into account in decision-making process. And finally, to conclude, the next slide, please. The next slide, please. I give a conclusion that the provision of AMDAL in the Omnibus Bill violate the general principle of environmental law. There are at least 4 principles of them, which are the principle of preventive actions, of course, and the second one, the principle of non-regression, meaning that it is prohibited to set a new lower standard for protecting the environment than the previous standard, and the principle of progression, meaning that the new standard should be set higher than the previous one. And the fourth, of course, the principle of subsidiarity, which stipulates the decision of environmental matters should be made by a closest institution where the activity is located. This is because, as we discussed earlier, the impact of the activities is such specific. So we need to get the institution, the closest institution, to make the decision. If we give the decision to the national government, then the national government is not aware about the diversity, the conditions, the environmental condition across the archipelago. In addition, the bills also in contradictory to the guiding principle of the EIA process, namely participation, credibility, transparency, accountability. We can discuss this earlier during the Q&A session. I guess I will stop here. Thank you so much for the time.
Thank you so much, Mas Igam, for the explanation on EIA. I believe that it really gives us, a lot of knowledge and a lot of new knowledge, especially regarding the the plan to be enacted omnibus law that, have been really a subject to debate for a lot of people. So previously, I kind of have make problem. So for those of you who have not known, but I believe that majority of you have already known that Mas Igam is our lecturer in the Environmental Law Department, Faculty of Law, Universitas Gadjah Mada, and Mas Igam have already obtained a PhD degree from Murdoch University on the topic of law, space, and development, and also a Master of Law degree in Environmental Law from the School of Law, University of Nottingham in the United Kingdom. So I believe that Mas Igam have also wrote a lot of articles also, Mas, regarding environmental law, and you guys can access it at academia.edu/UGM. There you can see that Mas Igam have, wrote a lot of things regarding environmental law, space law also, and I believe that such writings can be also contribute to all of our knowledge regarding environmental law, especially in Indonesia. So, Mas, if I may have a little bit of discussion, because honestly, some of the materials that you deliver also catch my also catch my interest, especially in regards to omnibus law. Can you unmute, Mas?
Yes, please.
Thank you so much, Mas. So I'm very interested in the fact that there seems like this is like only a slight of a change, but it actually contributes a lot because in the omnibus law, it is seen that the scientific review is changed to bureaucratic review. So in this case, I believe that it can also be problematic because when that happened, then the actors, the private entities that is required to conduct the assessment can already possess like a pre-existing bias towards the company in question. So they were under the assumption that no matter what happened to the environmental, the utmost purpose was to grant the license in order for them to be able to operate and also to gain benefit, which would of course benefit the investment sector in Indonesia. But if we take a look into the environment perspective, then it would be really dangerous because there will be a lot of things that could be, undermined, Masigam. So, how do you think about the solution to this problem, Mas? Is it still possible for that to happen while also, asking the relevant actors such as the scientific methods to also be applied in this case?
Yeah, thank you for the questions. I believe that we need to put the AMDAL document as a scientific document. Yeah? That's why the best way to assess or the best way to review a scientific document is through a scientific committee. Yeah? Those who have already competency, already have knowledge, already have experience, yeah, in assessing scientific document. Of course, we as ordinary citizen do not acquire that knowledge. So let's give the review process conducted by the scientific committee, names the Komisi AMDAL, consisting of the scientifics who have knowledge on that topic. By omitting the Komisi Penilai AMDAL, I see that there would be a detrimental impacts on how we treat the AMDAL document. The AMDAL document is not going to be seen as a scientific document, but rather as a formalistic requirement. Yeah, only formalistic requirement or formalistic document in order to get environmental license, environmental permit. That's why the scientific review has been will be replaced by bureaucratic review, reviewed by the government official. Yeah, we know that the government is biased toward the economy, right? They have their own, back in their mind, they need to pursue economic development. They need to pursue economic growth. Once they need to review a scientific document, they already have that bias. Yeah, they will, of course, they will use the economic perspective as overriding perspective to see a scientific document. Yeah, this is not the document no longer as a scientific product, but it is a political product that can be justified for economic development. And that's the danger for bureaucratic process, because the bureaucratic process, the government officials already have their bias to pursue economic growth. And also, can you hear me? It's a bit, sound is a bit noisy behind.
Yes, but you can still.
Okay. Yeah. Also the problem with that is that, like I said, there will be a transfer of monitoring mechanism from the local government to the central government. We know that central government has a very limited resources, have very limited personnel, staff to monitor all the projects across Indonesia, right? And then, although the government know that it has limited resources, why they then seems to insist they would be able to monitor. And that's why I put this as an argument that this is about the politics of impossibility to monitor. Because they know that it's impossible to monitor. They know that they are lacking in capacity and lacking in resources, but they still insist the monitoring authority will be given to them because they don't want really to monitor that. Yeah, that's why I call this the politics of impossibility to monitor. The impossible to monitor. The Ministry for the Environment is impossible to monitor all the projects across Indonesia. And that's the consequence. Consequently, the project proponents would not be bothered themselves to comply with the regulation, to comply with the recommendation in the AMDAL document. So they would see themselves, okay, no one would monitor us. That's why we can do what we want. Yeah, because it is impossible to monitor us. Yeah. How can the national government would monitor 100,000 or even millions of projects in Indonesia? Meanwhile, their staff are very limited. So that's impossible to monitor. That's the biggest problem in the future of the AMDAL.
Okay, thank you so much, Mas Igam, for the answer. I think maybe many of you are still curious about first of whether it is really proportional to, say that this would develop the economics of Indonesia while also sacrificing a major product for the environmental law licenses. And second, I think we will also further discuss on the effect that would happen should this omnibus law is totally enacted in Indonesia. So thank you so much, Mas Igam. We will further continue our discussion in the next question and answer session. Thank you. Okay, so we will move to the second speaker. Hello, Mas Yuyun, are you there?
Yeah, Audrey.
Hi, Mas. How are you doing, Mas?
I'm good, thanks.
Okay, I hope that you're staying healthy in this midst of pandemic. So firstly, I would like to kindly introduce Mas Yuyun to all of you guys. Mas Yuyun Harmoni from Boronegoro, and Mas Yuyun have conducted formal education in public administration major in Faculty of Administration, Brawijaya University, Malang, Indonesia. And Mas Yuyun have also participated in a lot of job experiences. Him to be appointed as one of the employee in climate justice campaign manager of the Indonesian Forum for Environment. While he, of course, all of us are not have already heard about while he and how much it really impacted our environmental law system in Indonesia. Mas Yuyun have also participated as a researcher of transformasi in the Center of Public Policy Transformation, and have also become a member of Resources Politics Working Group in Stiftung Eisenhaus. Right. It also Mas Yuyun have also participated as an intern in Indonesia Forum of Environment before he finally appointed as the manager in climate justice campaign. So that's for only some of Mas Yuyun's job experiences. And Mas Yuyun is also actively writing, and some of them have also been publicized. One of them is on the precarious lives on transnational biographies of migrant oil palm workers in Asia Pacific viewpoint. So that is really amazing, Mas Yuyun. I can't wait forward, and I believe that all of us can't wait forward to hear your material. So the time and floor is yours, Mas.
Yeah, thank you, Audrey. But first of all, thanks a lot for inviting me in this really good forum. And I would like to say hi to Bli Agung. It's been a couple of years we haven't met each other. But Bli Agung really know a lot, and he already said everything, so I think I already explained some of it. Maybe a twist of things that we need to understand on why the governments are now reducing the environmental requirement for the development, and what is the future expectation for us as a youth. Yeah, not for me, I'm a bit old, but for you guys, on how to pursue, or how to imagining the future of Indonesia. I would like to share a couple of my presentations, if I'm allowed.
Yes, Mas, you are certainly allowed. For the committee, can you please give able to share his screen? Okay. Yes, it's already there, Mas.
Yeah. Okay. I'll make it bigger. Right. Yeah. So my presentation would be the deregulation leading to the climate disaster, but not only on climate, on how the Omnibus Law will redefine our future and our environmental governance. The Omnibus Law, for me, is like this machine. Yeah. If we see in terms of input and output, yeah, you can see the input is the natural resource, as well as the cheap global labor, yeah, and then it will process it in the machine to achieve the highly growth, right? And then at the end, it will emit a lot of carbon emission, as well as the environmental destruction, and also the problem of waste that we are facing it right now. Yeah. So this is exactly what the Omnibus Law are designed, because it want to achieve highly growth. Yeah, because in Indonesia, in a couple of years, especially during the Jokowi administration, we only achieve in relative 5% of growth. Yeah. In 5 years. So actually there is no increasing of growth. No? And then the government thinking, if we want to be a prosperous nation in the 2045, at that time when we have 100 years of independence, then we need to achieve a highly growth, right? And how we do that is by losing all or lessening all of the requirement, especially the environmental standard, the labor standard, yeah, and other standards that it's part of the safeguard of the economy, and then we will push through the machines so that it can produce more growth and so on. But the government doesn't really care about what the damage that will create it. For example, the pollution, the climate breakdown, the climate crisis, the environmental destruction, deforestation, and so on and so forth, as well as the problem that they are facing every day, especially for the waste problem. So 82 laws will be deregulated, and this deregulation are part of the government's ambition to push the economic growth, yeah, and they say that it will guarantee us for the prosperous future. But we will talk that later. For the environment's organization, there is, especially in WALHI, there is 6 concern. All of it already mentioned by Bli Agung. The first one would be in terms of the meaningful participation and consultation, yeah. Previously, the environmental organization, people that are indirectly affected by the project, they can be involved in the consultation. But then in Omnibus Law Cipta Kerja, the job creation, they're not allowed anymore to involve in the process. Yeah, so there is no meaningful consultation, and I agree with Bli Agung that it's not only the environmental organization and also the people indirectly affected, but it seems that the academician, it's also being restricted to be involved in the meaningful consultation as well. The second one is that AMDAL will be only measured in terms of the risk. Yeah, so only for the high risk sector would require an AMDAL. So the activity or development that it's not high risk, according to the government, it's not required to have an AMDAL. But what is the definition of risk? We don't know yet, because the government said it will be defined, the risk and the threshold, in the PP or the government's regulation. So we haven't seen yet how they define the risk and how they define the threshold, because the government's regulation is not there yet. And we assume that the government regulation will be there if the Omnibus Law Cipta Kerja, the job creation, it's agreed by the parliament. No? The third thing is that the environmental permit will be removed. It will be replaced with the environmental approval. Yeah? We don't know yet what is the meaning of the environmental approval, yeah? But we know the meaning of the environmental permit. The environmental permit is important because it is the prerequisite or requirement for a business license, right? And then it's also stated that this environmental permit can be challenged in the administrative court. And exactly that is what WALHI and several other organizations are doing when we are rejecting the harmful development, for example, the coal power plant, and then we challenge them to the administrative court using this environmental laws, saying that the environmental permit can be challenged in the court, especially the administrative court. And we did it several times. Some of them are succeed, but some of them are fail. But at least that is how people can exercise their right to justice, yeah, especially in the court system in Indonesia. The fourth thing of our main concern is that regarding the sanction and punishment, yeah, in our environmental law, it's stated that the punishment or the sanction can be administrative, criminal, and civil sanction at the same time. No? But then in the Omnibus Law job creation, they will put forward the sanction of administrative first. No, so it's not in parallel. No, for example, when the KLHK or Ministry of Environment and Forestry, they will put companies in court because of the forest fire. They will ask for the sanctions in parallel way. So it's administrative sanction, criminal, and also the civil sanction. But then in the Omnibus Law, the administrative sanction will be put forward and not the criminal and civil sanction. The fourth concern is that about the elimination of strict liability in the Omnibus Law. This is the principle that we are using against the companies who's neglecting their responsibility. Yeah, for example, the palm oil or pulp and paper companies, when where the fire are happening in their concession, they are automatically responsible for that. So the government doesn't have to prove who's the one who setting up the fire at the first place, but then the company have automatically responsible for that. That's the principle of strict liability. And the last one is that, as Bli Agung mentioned before, all of the licensing, supervision, and sanction will be centralized to the central governments. Of course, it will create a lot of problem because the governments are not equipped enough in terms of financial and also the human resource to have supervision of all of the development in Indonesia. And in some cases, for example, while he advocating in the local offices, because we have 28 local offices, in Central Sulawesi, for example, the governments are rejecting the development of palm oil plantation, but then the central governments are giving the permit. So, sometimes it's difficult for us, because we have to play both ways, because sometimes the local governments are giving the permit, especially the extractive industry such as big plantation. But then in these cases, for example, in Central Sulawesi, in Buol, the local government are rejecting the development of palm oil plantation, but then the permit are coming from the central government. And I think it's dangerous to allow centralization, because it's also didn't comply with the our autonomy's regulation, And then what is the consequence and how we see the future, Well, the government say that the problem is economic problem, no? And for now is for sure is the health problem, right? Because of the pandemic and so on. But then there's a crisis, crawling, and that's the climate crisis that not being assessed by the government, no? Because the climate crisis, it created a lot of disaster, especially for the people who living in the coastal area, as well as people who work as a farmer, no? Because of the flood, the rising sea level, and so on. That will create a lot of disaster, and in terms of economic, there's also a cost for that. But the governments did not assess the future threat. Instead, the governments always see, as Bli Agung said as well, in terms of the economic dimension, not the other things around. For example, the climate and also the health crisis. Is this the future that we want? This is the picture of a thick haze in Jambi last year, in September last year. The sky in Jambi are turning red. This is also the indication that the nature give us the red lines, that we already crossed that line, and they give us the red card by showing us the red sky. Is this the future that we want? And this is the companies that create the disaster. It can be the palm oil companies. It can be also the pulp and paper companies, and it's also created by the logging companies. And it's related with AMDAL as well, because they got the concession from the governments. And if we losing or we reducing the requirement for environmental permit and AMDAL, then this is the future that we are facing, and it surely it will happen again. Now, how we can assess the perform of countries, using not only the economy but also several other things. No? There is you can see in this website. It's how we can have a good life in the limit of Earth and in the limit of our social societies. No? So you can see that we can compare how the perform of the G20 countries, yeah, which Indonesia is part of the G20, and how Indonesia is performed on that sense. We can see all of the G20 countries, they already pass, or they already use the resource, yeah, crossing the resource or crossing the limitation in terms of CO2 emission and in other measurement, yeah. For example, the ecological footprints and also the land use sector. And if we see Indonesia, we also already pass, or we already breaking the boundaries of CO2 emission, yeah. And the next slide, I will give you the exact calculation of that. No, we haven't passed the land use change and also ecological footprint and also the material footprint, because most of the material footprints are created by the Annex 1 country, the North, yeah, in terms of geographical and political definition. But then for Indonesia, we are lack of life satisfaction. Yeah, we also lack of sanitation. No? We also lack of nutrition and so on and so on. So the government should assess in terms of this category instead of only saying we want to have a growth, and then by having that growth, then our community or our people will be prosper, because it didn't seem so, right? And this is the exact calculation of that. This is also to prove that the economic growth of 5% during the Jokowi's administration, it doesn't relate directly with the life satisfaction of the community. It doesn't relate directly with the sanitation of community, and it doesn't relate directly with the income, because when you see the threshold in income, it should be 95. Yeah, it should be the people who earn one or at least $2 per day. It should be 95%, but instead Indonesia, we only have 84.1% of the peoples of the population who earn at least less than $2 a day. So, I mean, we need to assess our development of the country not in terms only on the economic, but also in other sector as well. For example, healthy life expectancy, and so on and so forth. This is the new proposal that we need to assess. We need to have new way of thinking on how we're going to develop for the next until 2045, for example. And then we need to assess our development not only on the economic sector, but also in other things as well. And in order to do so, we have to strengthen our environmental policy instead of reducing the environmental policies or social and also the labor policies. We need to imagine the next future by introduction of the notion of degrowth instead of pushing growth but without prosperity, and also destroying the environment and creating the environmental and climate destruction. That's a little bit of my presentation. While he will be 40 years old in this 15th of October, and we still commit to work together with the local communities against the destructing project, and also with the youths and the future generation as well. Thank you.
Thank you so much, Mas Yuyun, for giving us a lot of new insights also in regards to all of the concerns on Omnibus Law and how it would really affect our future lives. So I deeply note that not only that it would affect the climate change to become worse, but it seems also that all of the sacrifices to the environment made by the regime, made by the government, apparently does not relate directly to the people's welfare. And it seems like the only growth that have been achieved is only 5% of growth. And the fact that this does not really relate with our, our development of lives, it is kind of like really, really concerning. So before we move on to the next speaker, I want to discuss with you a little bit on some of the concerns that you have previously mentioned regarding the new law that might happen should the omnibus law be really enacted. Is that okay, Mas? Should we conduct a little discussion?
Sure.
Okay, so Mas, one of the concerns that I really note is that the principle of strict liability is deleted from the newest draft of omnibus law. It would mean that the automation of the owner's responsibility when it comes to environmental damages is dismissed. Can you give us a bit of a perspective on, what kind of an impact that would happen should this principle be deleted, and how is it going to be done in the future, Mas?
Yeah, the consequence would be it's easier for companies to burn their land for expansion, and they didn't punish for that. Right? Even though they get punishment, it will be an administrative punishment instead of criminal and civil punishment. Right? So in that sense, it will be easier for the companies to get away from the charge, yeah, if it's coming from the government or civil society. And then I think it's also they can get away from the harmful activities that they are doing. And for us, it's like a setback from our achievement, yeah. Not only the environmental organization but also the governments, because the governments in a couple of years they put the harmful company in the court and they are win several times, and they got reparation for that activities. What we don't see is that the government didn't revoke the permit of the company yet, but it doesn't have to be that we are lessening the standard, right? We need to strengthen that, and this is also not in line with our commitment in the Paris Agreement that we will reduce a lot of our carbon emission, especially from the land-based sector. If we remember, in 2019, almost 1.5 million hectares of forest and peatland are burned across Indonesia. We didn't see that in 2020. It's because of the changing of the climate. Well, when the El Nino is disappear, but the La Nina, the climate situation that will create a more heavy rain and so on is happening this year. But we have to take precaution so that the forest fire will be not happen again in the next future, by strengthening our environmental law instead of deregulating it and then make it easy for the companies to get away from their harmful activities.
Thank you so much, Mas, for the answer. I also note that in omnibus law there is a certain standard that have been dismissed, so that might create the fact that maybe some of the basis that usually is enacted for companies to not be able to operate due to their possibly environmental damage that could be created out of their business might also be dismissed. And I've also read in some article, Mas, it seems that one of the state argument is that they really want to make environmental licenses are approval centered instead of regulation centered, as they sees that the licensing regime is a bit complicated, is deemed to be complicated. And in this case, then do you probably have any kind of solution, Mas, that the state should have been taken instead of just deleting some of the most crucial elements in environmental law regulations?
I mean, there is something that the government didn't do. Yeah, for example, the environmental permit after the enactment of the environmental law, 1 year after the enactment of environmental law, the environmental permit should be the one who's collecting all of the permit in terms of the environmental sense. No, so for example, the permit to dispose the tiling and so on, it doesn't have to be required on the specific permit, but it should be under the environmental permit. Yeah, but this is something that the government didn't do, and of course, this is not the fault of the law, but it's the fault of the government who didn't do that properly, right? So, the reason that we are a bit slow in terms of the environmental permit and so on, it's slowing down the process of getting the permit from the business sector. I think it's also because of the government didn't collecting all of the permit related to the environmental sense in one environmental permit, no, and that and because of the enactment of the government, then we have to reducing all of other thing. I think that's the not the proper way to solve the problem.
Indeed, thank you so much, Mas Yuyun, for your kind participation in the little discussion that we have. I believe that maybe all of the participants may have an additional question to ask to you later on the Q&A session, especially following up the question on, a lot of concerns regarding this possibly enacted omnibus law that may change our way of living probably in the next 10 or 15 years. And it is indeed really concerning when we see through the pictures that it is clear that in the future we might not have a blue sky, instead it would be red, should the state does not solve this issue and just kept on going with their agenda on the economic development. So thank you so much, Mas Yuyun. We will further proceed with you again in the next Q&A session. So next we will have Mbak Isna Fatima as our third speaker. Hello, Mbak Isna Fatima. How are you doing?
Great, thank you.
Hope
you are too.
Thank you, Mbak. Are you perfectly healthy? How is it going in there?
Yeah, great. I'm actually staying in West Sumatra, so it's far away from Jakarta, and doing work from home. Yeah.
Okay. Is there any, PSBB regulation, Mbak?
Yes, there is. Just recently, the government, the local government enacted a local regulation that, imposing sanctions to those who are not wearing masks. Yeah.
Oh, yeah, I see. It's been a lot also in the news. I've seen that people are getting sanctioned for like cleaning their root and everything else when they don't wear a mask. So I hope that you're in good health, Mbak. And okay, so now I will be directly introduced to you guys, Mbak Isna Fatima. So Mbak Isna have been working on Indonesia's REDD task force since June 2013 until December 2014. And further, Mbak Isna also worked for the Indonesian Center for Environmental Law. And now she's the head of division on forest and land governance. So this would include the job for the drafting, and also she have advocated the enactment of draft act on biodiversity. So that's really amazing, Mbak. Mbak Isna is from the Faculty of Law, Universitas Indonesia. She graduated in 2013, and her thesis is also about environmental law, especially on the sovereign right over plant generic resources for food and agriculture. Mbak Isna also studied in the Master of Law at the International Law and Global Governance in Tilburg University, and she graduated with cum laude. So that is a really amazing achievement, Mbak. Other than that, in addition to that, Mbak Isna have also conducted a lot of publications, and one of them titled "Coping with Forest and Land Fire Regulatory Challenges in Indonesia: An Assessment to the Regulatory Enforcement," and it has been publicized in the Journal of Fasil Stefanik pre Kalsafatian National University, and you guys can access that in the website. So that's all. It's just few of Mbak Isna's achievement in terms of environmental law, that is environmental law related. So please, Mbak Isna, all the time and floor is yours.
Okay, thank you, Audrey. I would like to greet Bang Yuyun as well, and also the Agung, who has given a very excellent presentation. I think it will be very fruitful for especially for you guys as our teacher, as Bang Yuyun also mentioned. Yeah, I will share my presentation. Can you see it? Yeah. Okay. I picked the title AMDAL Revisited with a quote, facing the pitfall of a weaker AMDAL, what we need to know actually, especially for you as a student, and also as our teacher, of course. These are the questions that are given to me. It focuses on the question around the abolishment of AMDAL and the plan to replace it to the detailed special plan or RDTR, Rencana Detail Tata Ruang. So yeah, because of these questions, and I compare it to the previous speaker's presentation, maybe I am actually preparing a presentation that is explaining the notion that are softer than what I usually do in other forum. So yeah, hopefully you can get the picture on how the government see this in my presentation. Although again, if you're asking my stance, of course it is similar to the album and also so I'm trying to deliver this presentation into four section. The first is why we need AMDAL, just a little bit because the album already mentioned it comprehensively. And the second is the attenuation of AMDAL. Is it a trend? Because your topic is about the abolishment of AMDAL, but what we see from the development of the discussion on the omnibus bill, it is actually the attenuation, not necessarily abolish completely the AMDAL, but it is actually weakening. And the third is about the detailed spatial planning and AMDAL. Are they actually can be substituted? And the last is try to deliver and maybe discuss our role. The first is why we need AMDAL. Well, yeah, the album already mentioned from the theoretical perspective. And in our current Environmental Act, we can see that AMDAL is an instrument of many means. It is a tool for open the space for public participation, and it became the basis for us as a community to monitor the activities, and it can also prevent conflict. Why? Because AMDAL process is deliberative, and it opened a wide room for consultation and not only scientific evaluation assessment, but also social assessment, and also it is part of the human rights safeguards. And AMDAL, from the perspective of government, is important for starting the coordination among governments from the very beginning before granting business permit. And it is also a source of information for all stakeholders involved in the process before granting a business license. And it can be a tool for applying a more transparent and accountable decision-making processes. And also from the government side, it is important for the basis for monitoring and enforcement, of course, to prevent environmental harm and also social harm. And from the perspective of government, it can be source for planning um, uh, in certain area. And also it is a tool for planning for the business sector themselves to continue their activities. And last one for the business, actually it provides information and all the processes actually help them to get a clarity and assurance for applying their business because they already get a social some kind of social license and they already can foresee what are the risks that they need to manage in their activities uh, by undertaking the AMDAL. As the Agung mentioned, it is not only scientific, but it is also part of the art. But unfortunately, AMDAL usually is taken as a pure scientific document or merely for formality. In Indonesia, it is more of the letter, because sometimes AMDAL is only, if you already have this book, you can call AMDAL, then you can get the license. But it's actually is not only that, it is actually also a tool for social license, and it is actually a legal document that is enforceable. And also, it is actually one of the bases to weigh and perform check and balances among stakeholders, which include community. And without proper regulation and enforcement of AMDAL, Bang Yuyun already mentioned some of the bad impact. We can foresee that without AMDAL, there will be insufficient basis for monitoring and enforcement, and also because of the lack of public participation from the process before issuing the permit. Of course, then the community wouldn't. There might be a prolonged conflict after the activities is started, rather than trying to prevent the conflict from earlier stage of the grant, the decision making or the permit. And without proper regulation and enforcement of AMDAL, in the end, at the end of the country, the state will bear more costs for everything. By granting the granting the permit, they will need to figure out by themselves what are the risks of certain activities, which we know that the government wouldn't have the resources, whether it is the budget or the human resources to undertake that. And what is worse, as Bang Yuyun already show us, at the end, the community bear the most of the externality costs without proper AMDAL. And yeah, now we see the trend for attenuation of AMDAL. First, we need to be honest on what is actually the problem that we face nowadays with current regulation. I completely agree that our environmental law now is one of the best law, as one of my colleagues from Asian Law Research Institute mentioned that among other Asian ASEAN countries, actually Indonesian law on environment is one of the best. But again, our biggest problem, as it is also a big problem in almost all countries, is that the implementation perspective. In case of Indonesia, I try to group in three problems that we face. The first is the data. The company actually usually fails to undertake proper and comprehensive feasibility study, so that they face difficulties in undertaking proper environmental impact assessment. Whilst a good corporation, a good businessman would must look the environment as part of their um, value, as part of their, also part of their risk, part of something that they need to preserve, they need to protect, because without the environment, they would not be able to pursue their business in a good manner. And also, it concerns their business sustainability. And the second is we don't have yet the comprehensive data on state of the environment. Or if we look into the Environmental Act, it's called Inventarisasi Lingkungan Hidup. We don't have it yet in a comprehensive manner, so that it is difficult for everyone, every expert, to start making the AMDAL, because even we don't have the data on the baseline of the environment. So they have to do a lot of primary research on the state of the environment before they can assess what are the risks that the activity will pose to the environment. And the last one is actually we in our environmental instrument, we need to have a account of carrying capacity of the environment before issuing a permit. For instance, like we have to illustrate, maybe we have a bowl and we already put a lot of kind of fruits there and water and everything. If we want to add something into that bowl, we need to ensure that what we add is not going to make this soup poisonous, or the bowl is not enough to carry all the components. That is how to illustrate simply. So we can imagine the environment without proper carrying capacity data. It is difficult to ensure that AMDAL can actually be enforceable. And the second box is the competence. We have to admit that our administrative authority is lacking in both making the implementing regulation and let alone to enforce it. And in fact, we have lack of experts that can help to create proper AMDAL. And the last is the integrity part, which is the biggest problem for our nation, is the act of bribery, corruption, and fraudulence in making in the process. And this is actually emphasized in many literature of seeing the developing countries' problem on enforcing their environmental law. And we can see actually the pattern for weakening AMDAL is already been started. The Agung earlier mentioned about how the law is being strengthened from time to time. But after 2009, actually, during the Reformation, after we have democratic era, actually we see the pattern of downside or the setback to environmental instrument, particularly AMDAL. For instance, in 2018, we have government regulation on online single submission, which has some stipulations that carry setback to environmental impact assessment, among others. First is, for instance, allowing some activities such as land acquisition, changing the land area, and production trials to be carried out before the completion of environmental impact assessment, which is weird. And the second is requiring unreasonable timeline, the completion of AMDAL. So we can see that they make the category and limit the sea tide into 60 days. And when I told this to my colleagues from developed countries, their first impression is they're laughing, because from their perspective, it is making AMDAL is not like you can always like limit it into time. You need to focus on the merits of the AMDAL, not with the time. So it might be a biggest can be a very opposing arguments between us who as a proponent of environmental law and the business sector, because they want everything to be fast, and also maybe the perspective of current government administration. And we have the broadened EIA exemption in the GR OSS, and also this will be upheld further in omnibus bill. And also in here, there is a privilege for national strategic project in terms of the requirement of AMDAL. And now in omnibus bill on job creation, which is, well, maybe will be enacted soon this month, sadly, we can see that there is a shrinking space for community participation, which really relates to us as a commoner. The elimination for environmental impact assessment community and replacing it with assessment by central government, and they can actually appoint certified institution. But again, it seems like the government see it only as a bureaucratic decision to make, and also when they add the norm of appoint certified institution, it's like they want to imply that, yeah, we acknowledge that this is a scientific document, but actually, if you look into the law of environmental law, we can see that it already stipulates a very comprehensive body of system on the process of AMDAL, because we have this commission that comprises of local government, experts, NGOs, impacted communities, which is already everyone that needs to be consulted is already there, but then they abolished this one. And then they also limit only to the directly impacted community, which is biased. And yeah, if we look into AMDAL around the globe, we can see that from the historical perspective, international, national, regional, there's never been any notion to abolish AMDAL or attenuate it. Instead, they trying to strengthen it. And yeah, I wouldn't explain too much on this slide, but just to give a picture of how this has been developed. And even some scholars already put a notion that it is part of the customary international law. It is part of the tool that can help us to apply the principle of non-transboundary harm beside the preventive action principle. And now we move into the question of whether RGTR can replace AMDAL. As you can see, that my notion is it is not a substitute. Well, this is the web of, yeah, maybe you can look it later if you want to go further to make a thesis on environmental instrument. Actually, here you can see how the connection between all the instruments that we have under the environmental law. And we see under the place of AMDAL, it's actually the last, and all this, the role of business is actually very tiny from all the instruments. So if we see from the government perspective, we should say that actually the business license is already given a very small part of it. Why would we consider that we still need to reduce this instrument while it is only a very tiny part from all the bodies of environmental instruments? And this is relatively the same from the previous one. And yeah, now we see what are the difference and the similarities of AMDAL and RDTR. We can see that actually the idea of exempting AMDAL when there is already RDTR and upaya pengelolaan lingkungan hidup dan upaya pemantauan lingkungan hidup, it's already under the government regulation number 27 2012. But I agree with Bang Yuyun, who mentioned that actually the government cannot afford to implement a proper implementing regulation based on the environmental law that we have, the 32 2009 Act. This is one of them because under the government regulation 2012, there's a flaw that adding that RDTR can actually replace AMDAL. We can see from here, from the scale perspective, AMDAL is for certain project, one project. Or we also have a project in one industrial areas. Whilst our DTR is for zoning, and it has limited scale of map, one, how do you say, 1:5,000. And whilst the UPL is also for project. But if we see the criteria, EIA is only for activities that pose significant impact to the environment. So not all activities are required. AMDAL, only the significant one. Again, there is already a limitation on what kind of business needs AMDAL. It only for significant impact. While our DTR is next, not really clear on what are the criteria of activities that can be placed under the area. And UPL is for other than those who pose significant impact to the environment. That's why UPL is only, you need only to fill a form, whilst AMDAL you need to do a compact assessment just like you're making thesis actually. And then the instrument of AMDAL is comprises of term of reference, analysis or assessment, and the plan for management and monitoring. While our DTR is a map of zone and also which is instrumentalized through government regulation, local government regulation. And then the UPL is only in the form. And from the perspective of public participation, in AMDAL, public participation is at the center of the process. It is the heart of the process. Whilst in RDTR, the public participation is limited, not specific to project for activities. It's only because it's a planning. It's not for certain activities. And the UPL, there is none. Only by announcement of the environmental permit, which is according to Omnibus Bill later will be deleted. And the last one, when you talk about our role, well, Omnibus Bill actually talk about how we want to achieve better development, but actually this is not a very new discourse globally. We know that there are some theoretical debate based on empirical findings that from the left side, we know that there is a theory of environmental Kuznets curve, which is actually which notions is actually when you are a country can strengthen environmental regulation in the end after they after they attract a lot of development and they and the people really feel the degradation, the impact to themselves, then the state, the community will force a better standard for environment, and environmental standards will heal by the time. So it's like you're waiting for it to be completely degraded before you, it's getting worse before it gets better. That might be, can simply explain. And also there is a pollution heavens hypothesis where when, for instance, developed countries have set a very high environmental standards, then these investors will try to find other countries where the standards are more lenient, and then it and maybe and there is also a theory of race to the bottom, where when maybe because the needs of development, some countries not thinking of strengthening their environmental safeguards, but rather trying to make it more lenient because they really need the development. But actually, there is also a versus to this kind of view, which is some of them are Porter hypothesis, which notion is that actually stronger environmental safeguard standards and instruments for innovation by the business activities, and by doing more innovative, by making more innovation, then at the end of the day, the business itself can gain better profit than others who are not applying the innovation. And also, as opposed to the previous theory in the left side, is the California effect, for instance, when they apply a strengthened standard, and then the other countries are the other states in the US are trying to strive to following that standard. So it became race to the top. So yeah, for us as an academician and as a community, we can look into these theories and reflect to ourselves, which one would we prefer? Do we want to be a pollution heaven country, or we want to be part of those who are racing to the top, that we are in strengthening our environmental safeguards, whilst at the same time instigate business to innovate, to keep on doing innovation so that they can be a good investors, they can do their activities in a best manner, which are less detrimental to the environment. And also, yeah, they have already mentioned that we need to see it as a whole. Environmental rule of law and sustainable development principles is our should be taken into account, including the principle of progression and principle of non-degradation, which in a simple way demand country or state to not not making a regulation or policy that are going backward from what we already have. Instead, we need to make it better and better. So yeah, I think this is only for the discussion. I think from the academic point of view, we can contribute by providing the government with empirical studies on how these policies actually affect the in the field. You know, how, for instance, what are the problems that we actually face? Then the government can have a balanced and evidence-based information on how to actually improve the regulation and reform the law. It is something that we try to ask government to do that. What if we see from the academic paper of Omnibus Bill, it is very lacking. The Agung very known about that, very familiar with the poor quality of the academic paper of the Omnibus Bill. And then from the community point of view, again, with well, we need to defend our right, whatever it takes, and ensuring that the people have proper access to information, participation, and justice, which is already being upheld in the Environmental Act. So we need to fight for that not to be weakened, not to be attenuated. And from the lawyer's point of view, well, whether you will be corporate or public interest lawyers, well, if you face something like new regulation proposal or something like omnibus bill, well, we need to look into the detail, because it could be a clickbait, because nobody argue with job creation detail, but if you look into the detail, yeah, you will see how confusing it is to see it even from the business perspective. So if you're gonna be a corporate lawyer, it is important for you to really look at the detail. And from the policy point of view, maybe from the government, it is very, very important to have a well-documented data on the state of the environment, on the number of licenses. It is sad that until now we don't have a very comprehensive activities. If you ask local government how many licenses you have granted, they wouldn't be able to answer very comprehensive in a very comprehensive manner. That's the problem in our country until now. And of course, I put a stand on it is important to strengthen environmental standards and the enforcement system, and ensure that administrative authority can enforce the law in a transparent and accountable manner. And of course, we need to eradicate corruption and whatever it is relate to that. I think that's all my presentation for today. Maybe we can save for the discussion later.
Thank you so much, Mbak Isna, for the very insightful information, especially in regards to RDTR and AMDAL. I believe that some of our participants have waited for this moment to finally discuss about the issue on RDTR. So can I kindly invite you to our little discussion, Mbak, before we move on to the Q&A session?
Yeah, sure.
Okay, so but the issue on RDTR initially is happening since 2018, I believe. There has been, a lot of talking about the fact that the obligation for RDTR can possibly erases a company's obligation to have AMDAL or IMB, also ya Mbak, izin mendirikan bangunan. So in that case, I suppose that actually the three of these requirements is supposed to be like cumulatively, so that all of these standards that are required is fulfilled before a company is able to operate, to make sure that the environmental protection is indeed upholded. So my question is that why is this issue in 2018 become really important? But what is the underlying core of the talking of how RDTR can possibly replace either AMDAL or EMB?
Yeah, thank you for the question. First is actually the idea of having RDTR erase the obligation of business to conduct activities with significant impact to undertake AMDAL is already being stated under the government regulation 27/2012. But people, including us, are not really focused on that. We believe that, yeah, well, we can ignore that because that is impossible. But actually, in the norm setting, it is actually there. Well, maybe that is also our responsibility for not really look into that. And as the country grows and we aim for more development and want to be stronger country in terms of economic and political position, then the government wanted to conduct more national strategic plan, national strategic projects. that where they try to find how to like make this faster. And our current president aim is to accelerate the infrastructure development and other developments. So although actually the national strategic plan policy is already been started from the previous president, but I think it became one of the trigger where government started to see that, well, it is nice if we can like eliminate the necessity of AMDAL when we already have the detailed spatial plan. But the problem is what they don't really understand, and they don't really have a firm design on what is actually the RDTR and how it can to some point replace AMDAL, because AMDAL is very specific to project, whilst RDTR is a plan, and the output is mapped on what can be done here, what can be done there, but it cannot say what certain activities, what substance certain activities will pollute, what are the substance that certain activity will discharge to the environment. RDTR cannot say up to that detail.
Okay. Thank you so much, for the answer. And next, I would also like to discuss about the enforcement mechanism that you have previously mentioned. So, what do you think, of the current regulation and current system that have already exist? What is actually lacking from the enforcement system, and should we reflect this to see from the international platform? For example, like the practices for other states that have seems to develop more concern in regards to environmental protection. Can we really see, the difference? And I just want to have a little bit of an insight from you regarding of what should we do more in order to compensate for what we have done for the past years.
Actually, I just read a book written by Michael Farrer and Roy Partin about the law and economics of environmental law, if I'm not mistaken, the title. But it actually discusses how our environmental standards is actually learning from Western countries, from North countries. But why even if Western country already enforce it, they still face problems on the outcome of these environmental safeguards. But at least their administrative authority is really put their best effort to enforce the law, to enforce the instruments. But the problem that the writers see in developing countries is, the first is the authority is not equipped well from the with the knowledge and capacity and budget resources to actually apply these instruments. For instance, like we compare number of environmental inspector in Indonesia. We only have 160 in the entire archipelago, whilst in one state in Australia, in New South Wales, they have 250 environmental inspectors for only one state. But we have not, even we didn't reach 200 for this big country. That is typical the gap. And the second problem is actually the integrity part, which is the corruption, the bribery, and the tend to like make everything fraud. Like we can see AMDAL copy paste one corporation just copy others AMDAL, something like that. Yeah. So if we need to look it more thoroughly into the rule of law, to the enforcement of law, something like that. I think it's very complicated, but yeah.
Thank you so much, Mbak. So from what I get from you is that first, the enforcement mechanism should firstly be strengthened in order for us to combat all of these challenges. And one of them is to increase human resources in regards to and someone who really knows how the environment work, and which is why that the idea of replacing the scientific assessment with government assessment is, can we can say that this is a really bad idea, because that would just makes us go back to the previous way, before we actually develop things to where we are right now. And second, it seems that the problem on environmental protection is actually broader than that, because it also encompasses like the corruption issue, and everything else, the fraudulent issue that this country has. So should this environmental requirements is not upholded anymore, which means that some of the really crucial things is erased, should the omnibus law is really being enacted, then I believe that from all of our speakers' perspective, it would certainly not be a good development for Indonesia. We would just like go back to our previous stance before all of the development came from. So thank you so much, Mbak Isna, for the great insights. And now we would like to move on to our next session, which is the question and answer session. I have received few questions both from YouTube and also Zoom meeting from Zoom private chat. So should any one of you wants to add your questions, and should you can just chat me from Zoom and also YouTube. So we have a question by an anonymous attendee from Zoom chat. The question would be, in the Omnibus Law, there is a discourse to issue peraturan kepala daerah to regulate the issuance of RDTR, and as a way to speed up the making of RDTR. What do our speakers think of this? And does giving the kepala daerah a discretion to make a regulation regarding the issuance of RDTR may cast aside the environmental protection? I believe that this question is firstly addressed to Mbak Isna, if that's okay with you, Mbak.
Okay. Do I have to answer it now, or you need to
I
answer
think,
it directly?
yes, I will.
Okay. Okay. Well. Well, actually, I'm not really familiar with the acceleration of the RDTR actually, but from my perspective, in terms of giving more discretion to the local government, it is actually quite dilemmatized from the perspective of for policy making, because we understand that well, there is no guarantee that the local government can actually have will actually equip well with the capacity and the knowledge to establish a good quality of RDTR. But maybe for some areas, it can be, for instance, like maybe for Jakarta, maybe for Jogja, for the bigger area, the bigger districts or provinces, maybe they have more ability than central government. So it needs to be looked in a case by case basis, I think. And also, well, there should be a clear indicator on what are the good detailed spatial planning is. For instance, like the space for public participation, how you consult with your people, how you provide experts, and to what extent the planning, to the detail of the planning. I think there should be an indicator that are that can be a general basic standard for what the good RDTR is.
Okay, thank you so much, Mbak Isna. Mas
Can
Igam.
I add on something on that
Yes,
issues?
sure can, Mas Igam.
Yeah, because it seems that all the questions related to RDTR in the chat box in the Q&A questions, there are 3 questions and all related to the RDTR. Yeah, I just like to add on what the, Isna has mentioned excellently on the relationship between RDTR and the AMDAL. Of course, the assumption why the AMDAL the obligation to have AMDAL in the first place can be omitted because in one area, if the district has RDTR already, because in order to have RDTR, you need to start from conducting strategic environmental assessment. Yeah, the strategic environmental assessment is the instrument you to calculate the carrying capacity of this area, and then by knowing the carrying capacity of the area, you know what kind of activities are allowed and what kind of activities should not be allowed to take place in that area. And in the RDTR, it's not only about zoning on what can be undertaken in that area, but also it stipulates the design as well, the building designs, what kind of building, and whether you can build 3 floors of factories or houses there in that area, meaning that RDTR already detailed in that manner, because it's not only stipulating the activities can be taken place in that area, but also the design of the buildings also be there. And from that assumption, then the government tried to draw a conclusion, because RDTR already detailed, so we don't need AMDAL. So the companies only goes to conduct UKLUPL. Yeah, because already there, because the impact already calculated, and then what the companies should do is just to provide the UKLUPL, then you get the environmental permit. And just like Irna has said, of course, that's kind of misconception, how to put RDTR in relation to the AMDAL. The first, RDTR is very general norms. It is a regulation that apply to everyone. Meanwhile, AMDAL, that leading to environmental permit or environmental license, is decision, administrative decision from the government. It basically applies to very specific project, very specific project properties. Yeah, that from that point of view, those two cannot substitute one another. You need the RDTR. In the same way, also you need AMDALs and environmental permits, because RDTR is the regulation applies to everyone, the general apply to the general public. Meanwhile, if you have your particular project, your personal project, then you need to have an administrative decision. Yeah, or we sometimes in the administrative law classes, we learn about regling and bashiking, right? Yeah. The environmental permit and AMDAL is the bashiking, yeah, concrete, individual, and final. Meanwhile, the RDTR is regling. It's general norms apply to everyone. So you cannot substitute regling for conducting a very specific project, a single project. That's the idea. And also the acceleration or RDTR already there in the omnibus bill, where it says that the district head should enact the RDTR by certain time frame, or if I'm not mistaken, 2 years. And then if the district head has not enacted the RDTR within the certain time, then will be taken over by the higher tiers of a government, could be provincial government and national government. Why the omnibus bill regulates this thing? Again, this acceleration of the RDTR in order to weaken the obligation of AMDAL. That's the idea. Yeah, that once you get RDTR in one place, so the company does not need to go to the AMDAL process. Just need to go to the UKL-UPL process. That's my add on that. Thank you.
Okay, thank you so much, Mbak Isna, and also Mas Igam for making it much clearer of us that RDTR and AMDAL is indeed two distinct document where it may be that some of the element in RDTR is also present in AMDAL. However, not all elements in AMDAL is present in RDTR, which is why both are important. And just because RDTR have already been possessed, it doesn't necessarily mean that such company may have accomplished to have their own AMDAL due to one another consideration that may not have been available in the RDTR. So in accordance to that, maybe this is kind of like a follow-up questions because currently we are also talking about RDTR. So one of the question is from Christy through the Zoom question and answer forum. She asked that do our speakers think that environmental protection will still be guaranteed even if the issuance of RDTR is through the Perkada, and which we can assume here that the decision would also be influenced by Kepala Desa's interest and not the interest to protect the environment. Maybe this would relate to the possibility of a bias that can happen in terms of the issuance of the RDTR document itself. Maybe this can be addressed by Mas Yuyun, Mas. Should that be okay?
Yeah, sure. It's also been explained by the other speaker as well, no? But for me, everything can be biased. No? But in the beginning, you have to guarantee there is meaningful participation from the public at large and also from the communities impacted directly and indirectly, as well as the scholar community and the organization working on the environment and so on, to be involved in the decision at the beginning, right? Because Bli Agung already mentioned clearly that RDTR should be based on the strategic environmental assessment, and that in the strategic environmental assessment we can calculate the carrying capacity of an area or region, right? And that's the idea of calculating on what is the limit of our Earth, right? That is that exactly what I mentioned in my presentation. How we calculate the carrying capacity. Not only in the region, in district level, in our village and so on, but it should be also related with the carrying capacity of Earth. Because when we emit something here, it's also impacted not only the people who live surrounding this project, but it's also creating the climate disaster, and everyone will be impacted by that, right? So to have a proper strategic environmental impact assessment, and then we calculating the carrying capacity of a region or a district, and it guarantees the involvement of all of the public participation as well as the community would be the basis of the policy for the region. Then we can make sure, that there is no vested interest from the public official, especially kepala daerah, according to the interests of other non-state actor, for example, the companies and the business sector or person, which is going to drive the policy of RDTR. I think that's something that we need to take into account.
Thank you so much, Mas. Maybe I have an addition question to that. So you previously mentioned that the public participation is indeed required. So at least for this year, have there been any kind of movement that have been conducted yet being ignored by the government, Mas, especially from the related actors, including NGOs? Can you describe it?
Well,
it's a bit of an insight.
The recent trend is that shrinking space of civil society, especially the public at large, when the policy making process is only involving a few of people for the benefit of the few, not the many. Yeah. And that's exactly what happening during the several bills that being proposed by the government as well as the parliament. Yeah. And we see, for example, that the a bill that being proposed by the civil society, for example, the bills for indigenous community, as well as the elimination of sexual discrimination and harassment, is not being supported by the parliament as well as the government, right? So now the trends is leading to the shrinking space of the civil society in the policy making as well as in the decision making when we talk about the certain policies like AMDAL and so on and so on. And this is something that we are concerned, because it's leading us to the new order situation, right? So it's not leading to the betterment of our country, but it's set back to the condition where we have authoritarian government at that time.
Thank you, Mas. Maybe for Mas Igam and Mbak Isna, do you have anything to add regarding this new problem of the shrinking, space for opinion for the public at the current trend of the government? So please.
Shall I start first? Okay, thank you, Mbak Isna. Yeah. The shrinking space for participation, especially for environmental NGOs, should be seen as a common trend right now when the environmental law regime has been moved toward a risk-based assessment. Why I say that? Risk-based assessments require every interest should be quantified. Yeah, in order to decide risk and also to decide how to handle the risk, you need a quantified variables for decision making, especially also about how to quantify compensation for direct affected communities. That's why in the AMDAL process, the parties who are allowed to participate in AMDAL process under Omnibus Bill is directly affected communities. Why? Because directly affected communities, they can quantify their interests into money form. Yeah, for instance, they have a piece of land that will be affected, that be impacted by the companies from pollution and so forth. They can calculate their loss. Yeah, they calculate their loss. But for environmental NGOs, of course, they cannot calculate, because environmental NGOs participate not on behalf of the quantified interest, but on behalf of the environment. And when the environmental NGOs bring environmental interests, that cannot be quantified, that cannot be monetized. That's why it will be hard for the policymakers and the company to bring NGOs in the participation, because the currency are different. Yeah, the currency in negotiation is different. Once the company want to make sure that they use the currency of money during the negotiation, so they can compensate in the money forms. How much money do you need to be compensated? That's the question usually asked by the companies and the government. And then once the company provide that money, then the problem will be resolved, right? But if the currency is different, where the NGOs cannot use the interest, cannot quantify the interest of the environment using money form, then there would be no negotiation. Yeah, there would be no negotiation, and then the AMDAL process will deadlock, right? The example for this, the clear example for this is the Benua Bay Reclamation Project in Bali. Yeah, Mas Yuyun already familiar with that. why this AMDAL process has been for years stuck or in deadlock, because the local communities in Bali, they didn't bring, they stick on their interest that the area is a sacred space. That's a sacred space. By designing this, by bringing the reason of the sacred space to review the project, the company cannot calculate them. The company cannot monetize them. Yeah, that's why there are deadlocks in the negotiation process. And the companies and government are really aware with different currencies used during the negotiation between parties in the AMDAL process. That's why the environmental NGOs that bring the qualitative interest of the environment should not dare, because the NGOs might bring the hard time for the government and corporation to bring a fast negotiation process, because the interest cannot be quantified. That's the idea behind the risk-based assessment. Thank you.
Thank you so much, Mas Igam. And maybe for next, I would like to give the floor to Mbak Isna. But I just want to ask on your perspective on the fact that maybe some interests, for instance, environmental interests or, the interests of the indigenous people cannot be calculated based on monetary compensation. And in that case, what do you think is the most, is the best solution in order to, be able to balance the interest on both parties so that a deadlock would not happen?
Well, about the deadlock would not happen, I think the means of this instrument is actually to have the best outcome, the best decision. But the decision can be, these activities can continue or discontinue. So it's not about one party decided that this activity need to continue and it have to. No, but they have this plan, and then they discuss it with local community. They assess the risks to the environment, and if the results say that the activity will for instance, like will harm certain human rights or will detriment the environment to the state that irreversible, then the decision should be not to continue um, or to like think about other possible activities that can be applied there that maybe will not pose the same risk or compared to the previous plan. So if you're asked about the solution, actually, yeah, I don't know, maybe the environmental law is already, our environmental law is already like provide instruments that can help stakeholders to gain a best decision. For instance, like public participation in AMDAL, it's actually the implementation of partly like the free and prior informed consent by the people. So like it basically wanting the process to be the one who has the plan need to explain very clearly about what is the risk of certain activities and what are the benefit in a comprehensive manner. Although we and also that we to clearly understand what are the risks of these activities. But that is actually where the public participation plays a pivotal role, because the proposed the proponent need to explain very in a very simple but clear, understandable manner to the people, to the commoner like us, before we can have a stance, a way of we can have we can decide what are our stance, and we can understand what is actually the risk that will impact our lives. yeah, I think the instrument is already in our Environmental Act. It's just a matter of implementation.
Okay, thank you so much, Mbak. It's good that it's good to know that we already have a good, at least a really good instrument, and it's just a matter of implementation, which is pretty hard because it's been years since the establishment of the law in 2009. And thank you for that, Mbak. Now we would like to move to the next question. I assume that this is kind of still related. However, for now, we would like to see it from the perspective of the government. So the question is from Ajani from the Zoom chat. How should we balance between upholding environmental protection and state economy development? Or should we just put more of our state interest in environmental protection due to the concerning situation? I think this question is directed to Mas Yuyun. If it's okay for you to answer, Mas. Hello? I'm sorry, Mas. I think your microphone is still on mute.
Oh, sorry. Yeah.
It's okay.
Yeah. Well, whether the RDTR without AMDAL or even EMB would be sufficient, of course not, because all of other speaker already say that it should be not. It should be complementary. Yeah. So RDTR, AMDAL, and IMB should be a complementary. It should not be replacing. Time is also part of how we exercise the power of the central government as well. And I would take note very strongly on the involvement of public at large and the civil society during that process as well. Because without that, then it's only a matter of time when the government and also business sector would decide by themselves on what they are going to do with all of the policy, and not only about the RDTR.
Can I ask you a question?
Yeah, sure. Please.
Okay, so Mas, actually, this environmental licenses and the problem which surrounds it involves a lot of actors, right? It's not only the government, but it's also the affected actors, and also the public, and also NGOs, and so on and so forth. So in here we see that there's so many interests that is at stake. It is the state's economic interest, it is the environmental protection, it is the individual protection for indigenous people, for instance. The question would be, how do we balance this out, Mas? Is this the job of the government only, or it is the job of us all to be able to compensate to each other, including the assessment of the surrounding circumstances, which method would serve best, at least for Nomas?
Okay, thank you for the question, Audrey. First, I understand interest from Raskupan point of view. Yeah. He defines interest into three categories. The first one, public interest, is that interests are defined by the state as the representation of the public. And then individual interests, including the vested interests from the business sectors, and all also as individual also have individual interests. And the last one is social interests, the collective interests that not necessarily in line with the public interests and the individual interests that need to be aware of. And from this point of view, we know that states has been established in order to balance those three interests, right? Yeah, state need to balance that. In with regard to the environment, we know that Indonesia has embraced the sustainable development, where three-dimension economy, social, and environment should be balanced by the state. However, I'm a bit skeptic if state of Indonesia could balance that, as long as the state still follow the economic system based on economic growth. If the state still embraces economic growth, the state would not be able to balance their interests, because in economic growth, the the basic principle applies is that the economy should grow or die. Yeah, the principle of the economy is set up based on economic growth is grow or die. So either you grow your economy or you die. And then in this context, state has a state plays a very important role, yeah, to ensure the economy to grow. Once the state have a very important role to make sure the economy to grow, then the environmental interests should be overlooked, will be overlooked, and always be overlooked by the state, because the state plays their role in order to ensure the economic growth. Yeah, that's why I agree with Mas Yuyun during his presentation that we need to ensure that the state tries to find different alternative economic alternative. For instance, by the growth economic system, all donuts economy, where our economy can be developed within the ecological limits. Because economic growth doesn't recognize out there is ecological limits. Because the economic growth means that you need to grow exponentially, right? By growing exponentially, it means that you need natural resources. In fact, our natural resources in this earth is infinite. It's very limited. So it's impossible to have economic growth, uh, unrestricted economic growth within a very limited resource in this planet. That's why we need to reorientate, we need to rethink of our economy. As long as we have economic growth, then state would not be a neutral agent or not be a neutral institution to balance the economy, the social, and the environment. That's my take on that. Thank you.
Thank you so much, Mas Igam, for the very comprehensive answer. And now, due to the interest of time, I would like to move to the next question. It's from Mantari, and the question comes from our live session in YouTube. And the question is directed to Mbak Isna. So, Mbak Isna, can you please unmute yourself? Thank you so much, Mbak. So the question is, if AMDAL cannot be seen as only a scientific document, then can you explain to us of what actually is the difference between AMDAL and other public policies? And should we just see it as something similar instead, AMDAL and other public policies?
Yeah. Firstly, is the scale. Maybe the AMDAL is only for a specific project, one activity, one project, one for like one agriculture, one plantation license. Whilst policy talking about more general norms that are applied to all kinds of activities. And AMDAL is a mix of scientific assessment, social discourse processes, because there is a huge space for public consultation and also deliberative discussion among diverse stakeholders, including local government, experts, NGOs, community. So that should be more comprehensive and more detailed for such an activity. Yeah, I think that's in a nutshell.
Okay, thank you so much, Mbak Isna, for the answer. And moving on to the next question, I think it's also from Mantari again from our live session in YouTube. And this question is directed to Mas Igam, but feel free should Mbak Isna or Mas Yuyun have an additional answer to this question. So she is curious about the omnibus law, because aside on how the omnibus law negates the existence of EIA, is there actually a way or mechanism that is currently available to challenge the validity or credibility of EIA, especially in our state context, like in any kind of regulation that is currently available, Mas, please. I think we kind of lost connection with Mas Igam.
Sorry, was it for me?
Oh yes, Mas.
Directed for me? I'm very sorry because I lost the connection just now. So what was the question?
Okay, I will kindly repeat the question, Mas.
Yeah.
So the question is, aside on how the omnibus law negates the existence of EIA, at least some of them, is there actually a way or mechanism to challenge the validity or credibility of the EIA, especially in Indonesian context?
Yeah, of course. Because the current regime we have on AMDAL provide us or community or affected communities or those who feel loss, caused loss by the AMDAL decision, to challenge the AMDAL procedure, to AMDAL merit or the process through the administrative court, right? Because AMDAL, in the end of the day, should be transformed into environmental permit. And the environmental permit is an administrative decision, yeah, subject to administrative court. That's why you might bring the environmental permit before the administrative court in order to check the validity, the credibility of AMDAL process and even its merit. So you have that mechanism already in the current regime. However, in the omnibus bill, because the environmental permit would be erased and integrated into what is called as perizinan berusaha, then we could not split all the permit processes, and then we cannot challenge one particular process in that permit system because it's already integrated. So it will be hard for the community, for us, a public and citizen, to challenge the AMDAL in terms of a challenge particular process in AMDAL. That will be the drawback of this omnibus bill on access to justice. Thank you.
Okay, thank you so much, Mas Igam, for the very comprehensive answer. And is there any additional answer, maybe from Baisna or?
Persidangan ya di in legislatif ya in 8th of October. So all of the people who have concern on the omnibus law, then it should be speak up, and not only because we have restriction because of the COVID situation, the pandemic, then but you still have your online and social media, then you can speak up in that as well.
Thank you so much, Mas Yuyun. So the last question comes from Farah from the Zoom question and Q&A section box. So previously we have discussed overall thing about how our country regulates AMDAL and also another instruments and also all of the principles, including the right for the citizens to be heard. Now, Farah simply asked about the perspective based on international law because as far as we're concerned, upholding environmental principles does not only concern our own national interest, but it also, as previously mentioned by Mbak Isna, concern our objective and agreement to achieve the goal of Paris Agreement, for instance. So in terms of this, how can the failure of Indonesia to address all of this issue be a possibility for us to face another challenge on the perspective of other international actors? Maybe this question can be answered firstly by Mbak Isna, and maybe if Mas Igam and Mas Yuyun also have an additional answer to that.
Do I understand the question correctly? That what are the further raised by of Indonesian government in terms of the compliance to international agreements?
Yes, but particularly on omnibus law, since we have heard from all of you that it may erases some of the requirement that initially exist, then the question would be, what will that implies to the perspective of Indonesia from the international actors?
Okay. Well, basically, again, if we talk about international law, there is also a problem of enforcement. Actually, we have to be fair on that. That yeah, it is unlikely that there will be some kind of strong legal punishment for a state member, the parties that are not really obliged to certain international agreement. But from the political perspective, I think it plays a pivotal role because there will be rounds of, for instance, like conference of parties that where the international stakeholders and stakeholders from other nations can actually raise their voice and their concern as well to the adherence of Indonesia to its commitment on international environmental law. And actually, it already been started right now. I mean, I think a lot of some of international stakeholders, not limited to NGOs, but also from business sectors, is actually has made statements in the media and also sending letters to our government to like revisit it with the omnibus bill and ensure that whatever laws, that whatever instrument that they want to introduce now in order to cope with the economic situation, do or without with or without the pandemic as a cause, is not detrimental to the environment and human rights. So I think from the perspective of from the global perspective, when we talk about good stakeholders, including good investors, good government, good community, I think we all generally agree that whatever it is, the instrument, it will not pose setbacks to the environmental protection and human rights protection. Yeah, I think that's my answer. I hope it.
Thank you so much, Mbak Isna. Mas Yuyun, do you have anything to add? Maybe from the perspective of Walhi, have Walhi ever conducted any kind of audience or just receiving thoughts from international NGOs, especially regarding the environmental protection that have assumpted to be undermined due to this possibly enacted omnibus law?
Yeah, unfortunately not, but there is also a consequence if we are lessening the environmental regulation. Yeah, because, we are attached to some international commitment, especially the Paris Accord, the Paris Agreement, and we already enacted that in our national law, yeah, number 16, 2016, about the ratification of Paris Agreement. And in our constitution, as well as in the environmental law, there is also notion on the right to healthy environment. Yeah, and this right to healthy environments has been enacted by more than 156 countries in the world, but in the global level, it's not being recognized yet. But there is strong movement now since 2018 to to put this right as different rights, yeah. So it's not so it's a universal right to healthy environment, yeah. And while he is one of the organization in Indonesia that support the call to all of the government to recognize this right to healthy environment as a universal right, and of course there is consequence if we
monolithic entity, right? That the community that is very aware of on environmental protection, are supportive, are very supportive to the environmental protection. Now, we cannot assume the international community is monolithic, because there is also international forces that aim to be able to invest in uh, doing investment, doing business in those countries are easy or even hard to do investment in terms of licensing, in terms of labor standard or labor protection, and in terms of the corruption community at the international level has very lack of competitiveness in terms of economic competitiveness at the international level. That's why a long time ago, and clearly represented by the ease of doing business. And in this context, international communities, especially the investors, are celebrating what Indonesia is doing, right? By making investment as easy as possible, that investment might be able to come to Indonesia and with a very competitive cost for their investment. And I guess we should not see international community as savior for our problem, because international community also wants us
full discussion on the importance of AMDAL and also RDTR, and also another environmental concern that happens due to the new issue on the enactment, on the possibility of the enactment of omnibus law. So I thank you so much for Mbak Isna, Mas Igam, and also Mas Yuyun for sparing your time to discuss with us in here. And I'm sorry should I say something that offended anyone in here. So I believe that that's all from me. And we'll go back to the MC, Mas Zudi, please. Thank you.
Thank you, Kadri. Thank you also to the speakers and participants for the comprehensive and informative discussion. I would like to once again thank you to Kadri who has led our discussion today, and of course to our speaker, Mas Igam, Mas Yuyun, and Baisna. As a token of our appreciation, we'd like to symbolically hand over placards and certificates to our moderator and speakers, which will be given by the director of ALSA UGM, Kak Gaudi Demisha Averdi. Therefore, I would like to remind to all of the speakers and to Kak Gaudi to keep the camera on for documentation. For the first certificate and placard, we would like to give to Mas Igam.
Okay, so Mas Igam, thank you for joining us and giving us new perspectives regarding this topic. Always a pleasure hearing you teaching us in the Faculty of Law, and I hope you can accept this placard as a token of gratitude, and we hope to see you again in the future ALSA events. Thank you so much.
Thank you so much, Mas Gaudi, for the certificate and for the appreciation and having me here in a very exciting discussion.
Thank you for the documentation staff. Have you taken the picture?
Yes, I have. Thank you, Arya.
Okay, thank you. Next, would you like to give a placard and certificate to Mas Yuyun?
Okay. Udah, okay. Okay, to Mas Yuyun, thank you also for giving us great knowledge and perspectives of this topic, especially from the WAHI perspectives, and we hope that this placard serves as not only our token of gratitude to you, but also maybe the start of other joint programs between us, ALSA UGM. So thank you so much, Mas.
Okay, thank you, Kak Gaudi, for the documentation staff.
Yeah, thank you very much for having me and allow me to speak in this forum. It's been an honor for me, and of course we can still have a communication and can have follow-up activities between Wali and our friends in ALSA again.
Yeah, at least we can meet each other virtually, right
For
now.
sure, for sure.
Okay. For the documentation staff, have you taken the picture?
Yes, I have. Thank you, Arya.
Okay, thank you. And next, we would like to give a placard and certificate to Mbak Isna.
Okay. Okay, and last but not least, thank you, Mbak Isna, for sparing your time and joining with us today. Also giving us new perspectives revolving around AMDAL. And again, please accept this placard as a symbol of gratitude from us, ALSA UGM. And again, we look forward to seeing you again in future opportunities. Thank you so much, Mbak.
Thank you, Gaudi, and all the committees. I give a very great appreciation for you all for having this legal unplug, if I'm not mistaken. And it is very great for you as a student to very aware on what are the discourse developed out there, because once you will be in somewhere playing important role one day. Thank you.
Thank you for the documentation staff.
It's done. Thank you.
Okay, thank you. And lastly, we would like to give a placard and certificate to Kak Audrey.
Okay, and lastly but not least, thank you so much, Mbak Audrey, for participating in this event. Thank you for orchestrating this discussion into a very interesting topic. And always a pleasure having you here, both as a staff of ALSA UGM, but also as the president of CIMC. Thank you so much, Audrey.
Thank you so much, Gaudi, and all of the committee for this opportunity. I look forward to seeing you guys again.
Okay, thank you for the documentation staff.
It's done, Arya.
Okay, thank you. And our next session is documentation. So to all the committee, moderator and speakers who are on the panelists, we'd like to invite you to turn on your cameras. And for the documentation staff, you may take a picture now. Please turn on your cameras for all the committee speakers and moderators who are on the panelists.
Okay, I will begin the countdown from 5, 4, 3, 2, 1. Thank you, guys.
Okay, thank you, Jenny. And well, we have now arrived at the end of this session. Thank you for all the participants who have joined in our discussion today. And for the next agenda, which is jamming session and awarding, it will be hosted by my colleague, Fian. But before that, I would like to remind the participants to fill in the attendance form, which will be distributed by the committee in a moment. And once again, thank you for your participation and enthusiasm. Stay safe, stay healthy, and see you at Law Unplugged Volume 3. Wassalamualaikum warahmatullahi wabarakatuh. Shalom. Om Santi, Santi, Santi Om. Namo Buddhaya. Align for excellence. ALSA, always be one.
Thank you so much, everyone. Thank you, Mas
Agung,
Yuyun, Mbak
salam,
Isna.
Mas Yuyun.
Terima kasih, Mas Jagung, Mbak Isna. Yuk, kontak-kontak Mas Jagung ya.
Ya, siap.
Sip, ya.
Jadi kita
Oke,
siap-siap
Gaudi,
nih
ada
8 Oktober.
Oh iya, betul. Aduh, mobilisasi lagi nih. Oke, bye-bye.
Bye-bye.
Bye.
Okay, thank you so much Arya for having me. Good afternoon ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, peace be upon us all. Welcome to the awarding ceremony of ALSA Law Unplugged. We would like to thank you for your excitement on ALSA Law Unplugged over the past few days. As this year, ALSA Law Unplugged is coming to an end, it is now time to award our winners for the photography and song cover competition. These winners are selected amongst our participants as they showed outstanding performance and effort in advocating environmental issues and the beauty of our nature through photography and song cover. But before that, we would like to present you an amazing performance from ALSA singer. For Cynthia Sekar Ayu, time is yours. Happy watching, guys!
Thank you, Vian. Hi, everyone. One song from me, Wait from SWV. Enjoy. Don't know what it is that you've done to me. It has me to act in such a crazy way. Whatever it is that you do, I do it. It's a feeling I don't understand. As my heart starts beating triple times without some loving you on my mind. I can't figure out just what to do. And thousand more, it's you. I get so weak in the knees, I can hardly speak. I lose all control, and something takes all of me in the face, and it's so amazing. It's not a face. I want you to stay with me by my side. I swallow my pride. Your love is so sweet. It knocks me right off to my feet. Can I smell why your loving makes me weak? Time after time after time, I've tried to fight it. Your love is strong, it keeps on holding on. Resistance down, run, you're around, cause baby. In my condition, I don't wanna be alone. As my heart starts beating triple times without some loving you on my mind. I can't figure out just what to do. And thousand you, it's you. I get so weak in the knees, I can hardly speak. I lose all control, and something takes all of me in the face, and it's so amazing. It's not a face. I want you to stay with me by my side. I swallow my pride. Your love is so sweet, it knocks me right off to my feet. Can I smell why your loving makes me weak? My heart starts racing through my veins. Boy, it's something I can't explain. Something about the way you do the things you do. Of my feet. Can this smell why your loving makes me weak? Thank you.
Wow, thank you so much, Cynthia. That was a very, very nice performance. Thank you once again. Okay, and after that, I would like to present you guys performance from Mercy. Enjoy the video, guys.
soft show, wanna make you bro, never say to go. And you will know until just one say I love you more. Mama take you go, mama make you grow. And I keep my phone, she calls on me. I make you cry, I'm sorry mama. I felt this trust, this for you mama. I love you more, I love you mama. No wonder with me, no wonder with me. Just you flying, be my friend. Look at cold, wanna do my plane. Go to the sea, I'm flex, no curse. I'ma get brush. Pro cap, get up like first. I'm just looking my first. I wouldn't sing, I guess. Look at me, catch your fit and take it. Power, I'm the best and tricky. Flower, I can try and make it. Get her, and I dance, you like it. Mama dance this night, I'm chasing like it. Shiny, coffee, no one's gonna leave it, no one's gonna break it. I love you, no lies, thank you, mom. I make you cry, I'm sorry, mama. I felt this trust, this for you, mama. I love you more, I love you, mama. I love you, mama. No other with me, no other with me.
Wow, that was a very admirable performance. Thank you so much, Mercy. Okay, and now it is a time to award our winners for the photography and song cover competition. I'm sure all of you will be very excited for this. Okay, we will first award the winners of the photography competition. This year, photography competition anchored the theme of environmental heroes, and participants are scored based on the work, conformity with the theme. Second, creativity of participant through technique. And third, visual beauty of the work. Okay, and then among other participants, our third place winner scoring 8.32 goes to congratulations Valentino Mayang with his artwork entitled Hydroponic Farming. Congratulations Valentino. Okay, and the second place winner scoring 8.39 points goes to Muhammad Adnan Kasogi with his artwork entitled Pemuda Kartar Bersih-Bersih Kali. Congratulations Adnan. Okay, and for our first place winner, our environmental hero with the highest score in the photography competition with 8.58 points goes to Made Giani Kania Dewi with her artwork entitled Indonesia's Pride. Congratulations, Made Giani. Okay, congratulations to all winners of the photography competition. And without further ado, let us now proceed to the winner of the song cover competition. This year's song cover competition upholds the theme of environmental beauty and care. And then among other participants, this participant is able to secure her position in the third place. And congratulations to Cecilia Fini with her song cover of Colors of the Wind. Enjoy the song cover, guys.
Run the hidden pine trees of the forest. Come taste the sun, sweet berries of the earth. Come rolling all the riches all around you. And for once, never wonder what they're worth. The rainstorm and the river are my brothers. The hero and the other are my friend. And we're all connected to each other. In a circle, in a hoop that never ends.
Okay, thank you so much, and congratulations once again to Cecilia Fini. And this year, second place winner goes to congratulations Istiqomalia Yuniarti with her song cover of Colors of the Wind. Enjoy the song cover, guys.
Halo, perkenalkan nama saya Istiqomalia Yuniarti. Saya akan menyanyikan lagu Colors of the Wind by Judy Kun. Selamat mendengar. You think you want whatever lane you lay on. The earth is just a dead thing you can take. But I know every rock and tree and creature has a life, has a spirit, has a name. You think the only people who are people are the people who look and think like you. But if you walk the footsteps of a stranger, you learn things you never knew, you never knew.
Wow, that was very nice. Congratulations once again to Istiqomalia Yuniarti. Okay, and for our first place winner, our singer with the highest score in the song cover competition goes to Winda Chelsea. Congratulations, Chelsea, with her song cover of Colors of the Wind. Enjoy the video, guys.
You think you own whatever land you land on. The earth is just a dead thing you can claim. But I know every rock and tree and creature has a life, has a spirit, has a name. You think you only people who are people are the people who look and think like you. But if you walk the footstep of the stranger, you'll then think you never knew, you never knew. Have you ever heard the world cry to the blue corn moon, or asked the green bobcat why he green? Can you see with all the voices of the mountain? Can you paint without the colors of the wind? Can you paint without the colors of the wind?
never wanted what they were. The storm and the river of my brother, the hero and the other are my friend. How we all connected to each other, and the secret in a hole that never ends. How high does the sycamore grow? If you cut it down, then you never know. And you never heard the wolf cry to the black of moon. For when we arrive to skin, we need to see with all the voices of the mountain. We need to paint with all the colors of the wind. You can only see, and you only surrounded. You can paint with all the colors of the wind.
Wow, that was a very, very nice performance. Congratulations once again to Winda Chelsea. And congratulations to our winners of song cover and photography competition. But before we end this ceremony, we would like to present you guys the last performance from ALSA singer. For Nabila Ashishifanur, time is yours. Happy watching, guys.
Thank you, everyone. Am I audible, Vian?
Yes.
Okay, hello everyone. My name is Nabila Shifanur. You can call me Shifa. Today I would like to sing a song entitled "I Will Always Love You" by Whitney Houston. I bet you already know this song, so just please sing along with me and enjoy. If I should stay, I would only be in your way. So I go, but I know I'll think of you every step of your way. Everybody sing with me. And I will always love you. I will always love you. You, my darling, you, bittersweet memories. That is all I'm taking with me. So goodbye. Please don't cry. We both know I'm not what you need. And I will always love you. I will always love you. Life treats you kind, and I hope you have all you dream of. And I wish you joy and happiness. But above all this, I wish you love. And I will always love you. I will always love you. I will always love you. Will always love you. I will always love you. I will always love you. I love you, Unplugged. Thank you for having me today.
Wow, thank you so much, Shifa. That was a very, very nice performance, Shif. Thank you so much.
Thank you, Fian.
Okay, thank you, Shiva, once again. And then once again, congratulations to all winners of the song cover and photography competition. All of our winners' artwork will be posted on our Instagram account to further inspire each other, everyone of us, to continue our battle in preserving the beauty of our earth. We would like to thank you for all the participants for being our environmental heroes, advocating environmental issues and the beauty of our nature through art. We would also like to express our gratitude to everyone involved in this year ALSA Law Unplugged. We wish everyone a safe and healthy year, and we look forward to seeing you guys next year. Wassalamualaikum warahmatullahi wabarakatuh. Shalom. Om Santi 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 Om. Namo Buddhaya. Align for excellence. ALSA, always be one. Thank you guys. Thank you so much. See you next time. See you next year.